Section 140, that is removal of auditor. Subsection 1, read along with Rule 7. So, the auditor appointed under Section 139 may be removed from his office before the expiry of his term. Only a prior approval of central government is required by filing an application in Form ADT 2, and that too within 30 days of the resolution passed by the board. The company shall hold the general meeting within 60 days from the approval of central government, and the auditor shall given a reasonable opportunity of being heard. So summarizing, first, to remove the auditor before the expiry of the term, CG approval in Form ADT 2. Then after the approval, prior to that and after the approval. So prior board meeting, the resolution is required to be passed for the removal of auditor within 30 days. Look forward for an application with central government, and in further 60 days hold a general meeting, and in the general meeting for the removal of auditor, the auditor will be given a reasonable opportunity of being heard. So this was subsection 1. Talking about the subsection 2, resignation of auditor. So it's after removal, we're talking about the resignation. So the auditor who has resigned from the company shall file the statement in Form ADT 3 indicating the reason why, and maybe with the relevant regard to the resignation as follows. In case of other than government companies, auditor shall within 30 days from the date of resignation, a statement has to be filed with ROC. In case of government company, along with ROC, he has to file the statement with Comptroller Auditor General of India. So there's a very thin difference between the two. So resignation in a format of ADT 3. In case of other than government company, 30 days intimation to ROC, where in the case of government company, it has to give in the intimation has to be given to CAG, that is Comptroller Auditor General of India, and as well as the registrar. The burden of filing such statement, the statement with ROC and Comptroller Auditor, is with the auditor, and any contravention of the subclause 2 by the auditor shall be punishable with a fine from 50,000 or to the remuneration of the auditor, whichever is less, but which may extend to 5 lakh rupees. Moving forward, we have the power of tribunal. So this is your subsection 5, then later on we'll discuss the subsection 4. So subsection 5 say NCLT either by its own or application from central government or the person concerned can direct the company to change the auditor if it satisfies that whether directly or indirectly he has acted in a fraudulent manner or abetted or conducted any fraud in relation to the company and its director or officer. So in the case of application made by CG and the NCLT being satisfied the change of auditor it required, 15 दिन के अंदर अंदर जहाँ से एप्लीकेशन आई है ऑडिटर के NCLT के पास, he may order that auditor shall not function as auditor of the company and CG may appoint another auditor in his place. Now this will happen only when the application is made by central government and not any other person. So there is an exception for suo motu and on application from the person concerned. The 15 days format will not apply, and the CG will not given the authority as specified in this paragraph to appoint auditor of the company. So suo motu, person concerned and central government. So central government NCLT के पास application गई, CG within 15 days will reappoint the auditor of the company. So let's just construct it here again. So let's say NCLT receive the application from CG. NCLT within 15 days make an order to the CG that please appoint an auditor. Where the auditor is whether an individual or a firm whom the final order aforementioned has been passed by the NCLT under this section, he shall be ineligible to be appointed as auditor of the company for the period of 5 years from the date of passing such resolution, and क्योंकि fraud का case है, section 447 will be applicable. It has been very clarified by the way of explanation that in case of the firm has appointed as auditor of the company, the liability of the firm and every partner who acted in a fraudulent manner, abetted or concurred any fraud by in relation to the company or its director shall be liable and not be eligible to be appointed as the auditor of the company for the period of 5 years. Summarizing the entire scenario, suo motu on the application of the person that can direct on the application of central government. Central government has the benefit, 15 days order shall be passed, and CD has the authority to appoint the auditor of the company. Later on, if the such person is an individual or firm shall stand disqualified to be appointed as the auditor of the company for the period of 5 years, and section 447 shall apply for the punishment of frauds, which directly relates to 448. Further, it has been clarified that every partner who acted in a fraudulent manner in relation to the company directors shall not be eligible to be appointed as auditor of the company for the period of 5 years. So this was your subsection 5. Talking about the appointment of auditor other than the retiring auditor by special notice. So summarizing it from the beginning. So let's just say the special notice is given by the member to the company to appoint a person other than the retiring auditor to provide that retiring auditor shall not be reappointed. So such special notice shall not be required in case where the auditor has completed the tenure. Let's say the 5 consecutive year for the purpose he was appointed as auditor has been completed. In that scenario, such special notice is not required. Now how the procedure shall go on is, so the company on the receipt of special notice shall circulate to the retiring auditor. Auditor will make representation in writing to the company and request for his notification to the member. So once the representation is given by the auditor, it shall be circulated among the member. The representation shall state the fact of representation in any notice of the resolution. So while passing of the resolution, that shall have the facts and figures of the auditor given as the representation on the notice received to him in the resolution. So let's say I have a resolution, so resolved that pursuant to section so and so, at below you should also mention the representation which were made by the auditor. Along with that, the copy of representation shall be given to the members whom the notice is being sent, whether before or after the receipt of representation. Now the representation is not so sent due to the delay by the representation made by the auditor. In that scenario, the auditor shall have the authority to read out his representation in the general meeting, and the copy of such representation shall also be filed with a registrar, and representation should be of a reasonable length, not too long. So we consider not to hear a essay in a general meeting for a fact. For the circulation of member, it should not be received by the company too late, as I confirmed earlier. Auditor may require the company to read out the representation if it's not so notified to the members because it was too late or because of the company's default. Provided अगर किसी वजह से ट्रिब्यूनल को लगता है कि जो representation आपने दी है as a auditor वो that makes no sense, या power जो auditor को दी है for read out of the representation in the general meeting is abused by the auditor, then वो representation will not be sent and representation shall not be read out at the meeting. This was the retiring auditor section 140 subsection 4, the power of tribunal, removal of auditor and resignation thereof. Thank you so much.